Hi guys, welcome once again to Battle with Ola. This is Mojola Olua right here, and I'm so thrilled to be here again. Today we want to talk about letter writing. Writing letters is one of my favorite things to do as a lawyer. I love it so much. You know that part when you say we are solicitors to so and so, it just gets me every time. Like, I'm very excited about writing letters all the time. I'm a writer normally. I create content, written content, research articles, pieces and opinion pieces. I've written fiction, non-fiction, poetry, even drama, and what have you. So writing has always been like an integral part of my life. But when I became a lawyer, writing letters as a lawyer in a legal capacity, was just something that was very thrilling for me, and is still very thrilling for me. Like, it's an experience that I look forward to. It's so exciting to always be able to speak on behalf of others by letter writing. So in this video, I'm going to be showing you how to write a letter of demand and how to write a cease and desist letter. As a lawyer, you are authorized, you have the legal capacity to speak on behalf of your clients by letter writing. So it's one of the duties. It's one of the most sacred and most important duties, of a lawyer. And it's usually like the first step, when a client comes to you, exploring the option of ADR by writing a letter first before you head out to court. So today, let's start with how to write a cease and desist letter. I'm going to be using the example of a letter that I wrote far back in 2019, for a client who was being harassed by creditors. Someone had, fraudulently used her, according to what she told us, which appeared to be true, actually, based on, the facts presented to us. Someone had used her as a guarantor, contrary to her wishes, to stand in for a loan. The loan was called in by, the loan giving facility, and the person, the debtor, was unable to pay and was on the run, and then they were harassing our clients. We had to write a letter of cease and desist to them. That is, cease and desist from harassing our clients further if you do not want us to take legal actions against you. So you write this kind of letter when someone is probably being harassed, or when there's a trespass. It could be trespass to person, trespass to chattels, and trespass to immovables, what have you. Or if something is being done, contrary to the will of your client, or, affecting the will, the business, the person of your client. So you could write this letter to instruct or to command or demand that this person, the other party, cease and desist from further acts of trespass or harassment or what have you. And you do this just before you go to court. So if they comply, there will be no need for litigation. But if they don't, you could as well now go to court. So how do you start writing a cease and desist letter? The first step is to get all necessary information from your client. Who is this person? How do you relate? How do they come into the picture of your life or business or what have you? What brought you together? Do you have a contract? Are they connected to you in any way? And how did this act of trespass or harassment or what have you begin? And do they have any lawful claim against you? Why are they doing what they are doing? What do you want? That's the important thing. What do you want? So when the client has instructed you, don't forget that a lawyer is supposed to receive instructions in his chambers, not charge and bail under the tree, what have you. And of course, there will probably be discussions in the near future about, being briefed online via WhatsApp, Facebook, Twitter, Instagram, Zoom, or what have you, because those are like an integral part of a law practice now in contemporary times. There'll probably be discussions around that, but that's not where we're going today. So once you've been instructed by your client, this is what I want you to do. Write this person a cease and desist letter. Then you charge them for, the letter writing. So the first thing is, we're assuming that you're putting this letter on letterhead. So there's no need for us to do like an heading now. You have your firm's letterhead, which consists of your firm's name, address, motto, phone numbers, email, fax, what have you. Then we have your RF. That thing cracks me up all the time. If you've been to law school, you understand your RF. So you put your own reference, your firm's reference number for that letter. And that's like the reference number for the file that you're opening on behalf of that client. you're commencing the client's brief by way of that letter. You probably move into litigation or not, depending on the response to the letter. But we're assuming that the letter, it's assumed that usually letter writing is the way to commence most briefs, to commence most cases. That's like exploring the option of ADR. So your reference and then their reference, which they might put when they are responding to your letter. The next thing is the address of the addressee. You put their name or their role if it's like an institution, an establishment. Then you put the address. That's the physical address of the office number, so line, so city, so town, or so state, and country. If it's going outside of your country, you put the country. So that, and then you put attention. That is if you want a particular person to attend to it as a matter of urgency. That's usually done if it's going to a firm or if it's going to a company or an establishment, and you want it to go directly to a certain person. So you can put attention the manager, or attention Mr. So or Mrs. So. So that person would be the one that person would be like the person that has to respond to the letter or resolve the matter, or attend to the issue as a matter of urgency. So you put that. Usually your date will be up. I forgot to mention that. So dates should be up before your ref. Immediately under your firm's letterhead, you put date, then your ref, and then you put so your date should be up, and then you put the address of the addressee. After that, you put attention if necessary, and then dear sir or ma, or just put sir or ma. Then your title of the letter of so and so. In the case of the letter that we wrote a letter of intention to institute legal action. So it's a cease and desist letter. Because it's a cease and desist letter, it does not mean that you should title it a cease and desist letter, so to speak. But in this case, we just titled a letter of intention to institute legal action. So I think that suffices, for cease and desist. You can title it in any other creative way, that will just convey your message. And then the introduction, we are solicitors to so and so. You put the name of your client, and then you say hereinafter referred to as our client. Very important. That's the first paragraph of every letter that a lawyer writes on behalf of his client, whether it's cease or desist, whether it's a letter of demand, whatever it is. You can also title this letter of demand, actually, because you are demanding them to cease further acts of harassment. So you can also title it letter of demand. So the two letters that we want to look at are intertwined, interwoven, but they can be separated as well. So you can also say that letter of demand. So you say, we are solicitors to Mr. K.K. Solomon, hereinafter referred to as our client, in quotes, our client, in quotes. That's the introduction. Then you now go to the body, where you explain what has transpired according to what your client told you. So I'm going to substitute names and what have you as I go on in this letter, because it's a private document. It's a private document. If it had gone to litigation, it would have become a public document that I can share at will, but it's a private document. So I've given you an idea of what transpired and why we're writing the letter. So I'm just going to substitute a lot of things so that I do not reveal the identity of our client or the other party informed, because the letter actually did what we wrote it for. They actually stopped further acts of harassment to our client at the time. So the letter has done what it was supposed to do, so there's no need to reveal anyone's name. So I'm going to substitute now as I go to the body. You can say that, it is our client's brief, or it is our brief, or our client informed us. That's how to start the second paragraph of any letter you're writing as a lawyer on behalf of your client. So you make it known that you're reporting or you're acting based on what your client told you, so that if your client has misrepresented the situation to you, when they write back, they would not be offended in their response, or when they're taking action, you will not have aggravated your client's situation to not be a case of even as a lawyer, so you don't know, so you just believed your client without hearing the other party. The rule is audi alteram partem, hear the other party. So you report what your client said to you. So here we say it's our client's brief that sometimes in March, a certain agent of yours contacted our client to inform her that Mrs. Jocelyn Garba, who is reportedly your client, deceitfully obtained our client's credentials and signature as guarantor for a loan of 1 million naira only from you, which she has allegedly defaulted in paying and for which you have resorted to repeatedly harassing our client as the purported sole guarantor. Now, that's one paragraph. The next paragraph, we said, it is no gainsaying that we are shocked at your approach. The usual practice, which is known to law and in the banking sector, is that when a loan is sought from a credit facility, so and so and so and so on and so forth. So what we essentially said in this paragraph, I'm avoiding repeating a word for word so that someone would not dub what I've said and go and use it somewhere. Originality is the crux of being a lawyer, so it's very important. So you should do things creatively and innovatively. So I'm always careful when I share documents or when I share samples here, so you don't have to go and dub it word for word, you client sinker. But essentially what we said was that the usual practice in credit facilitation is that you verify your guarantors at the point of giving out the loan. Verify the guarantors that your intending debtor has provided. You call them, you probably go to their house or something. These days, very simple. Call them, send them an email. Are you guaranteeing this person? Is this to your knowledge? So once you've verified, you won't have a problem. So you won't have to be harassing the wrong person. So what we essentially said in that paragraph is that this is the practice. You verify at the point of giving out a loan. However, we noticed that you did not verify. Instead, you took your client's word for it. That's your Mrs. Jocelyn Garba. You took her words for it. And now at the point of recalling the loan, you are now harassing our client. And our client had no idea that this loan was even taken. How does that happen? How is the guarantor not aware of what he or she is guaranteeing? It doesn't happen like that. So we are shifting the blame to you. So please stop harassing our client, because this is on you. You didn't do your homework as a credit facilitator. You didn't do your homework, so you can't blame our client for it. So please stop harassing our client, or we will take legal action against you. That's what we said in the next paragraph, because it's a little bulky actually, so I don't want to read everything, but that's what we said essentially. And then usually in the next thing is to make a point out of how your own client has tried amicable settlement before contacting you, which has failed. So we said our client has in good faith done everything within our capacity to resolve this issue amicably, efforts which include reaching out to Mrs. Jocelyn Garba and her husband to appeal to them to pay up the loan, as well as giving you information as to their whereabouts as much as it lay within our power. So you make sure that after explaining your brief in the next paragraph, you make sure you outline or highlight the fact that your client has tried amicable settlement which has failed or been frustrated by the other party or by intervening factors or parties before taking the step to write this letter. And then the last paragraph is your demand, what you're asking for. Never forget it. You see that I'm following a sequence. So you first introduce yourself and tell us the lawful capacity by which you're writing the letter. Then you tell us what your client has told you has transpired, and led up to this point. And then you tell us that your client, has tried to resolve the issue amicably before resorting to writing this letter, that those efforts all proved abortive. And in the next paragraph, you tell us what you want, what you're demanding, what you're asking for. Remember, it's a letter of demand or a cease and desist letter. So tell us what you're asking. Instruct them what they should do, or tell them what you want from them. So we said that we hereby demand that you stop any further acts of harassment or disturbance of our client at a workplace, over the phone, or through any other means, as she has no business with you. Be informed that we intend to take proper legal action against you and your establishment in the event that you fail to adhere to this demand. So that's civil enough. So important for you to be civil and polite in your letter. but don't come off as weak as well. You have to be firm and civil. You have to merge the two. Matter of fact, in earlier times than we are in, lawyers would write things like, oh, if you don't accede to this demand, or if you don't do what you're asking, we're going to take legal action that will leave you, how did they teach us in law school? There's a way they taught us in law school. It will leave you wailing and whining and a whole lot of vocabulary. So if you like, if it does the trick, you could use it. If not, I think you should just avoid it. But just some words of threats, that's what they used to do. But now it's easier and better to be polite and civil. So you let them know that we are asking this because we want peace, not because we are weak, not because we don't know the right thing to do, not because we don't know our rights, and not because we are suspending our rights or conceding to your acts of harassment, but because we want peace to reign. So please cease and desist from doing so and so to our client, else we are going to take you to court and you will not like it. So there's a way you can couch that differently from what I've done, or you can do it the way we've done our own too. So that's how to write a letter. Then you end it with thank you for your anticipated cooperation, or any other thing that just closes it well. But just thank them in anticipation of a good reaction or a positive reaction. Then yours faithfully, you sign, you put your name, you put your role in the firm, and then you put your firm's name. So that's how to write a letter of demand or a cease and desist letter. You sign, you put your name, your role in the firm, and your firm's name. So that's how to write it from start to finish. Just speak a little about writing a letter, another type of a letter of demand. Here I wrote to a company that wrongfully terminated my client's employment. Like I told you already, the letterhead is there already. Here's a copy of the letter. I'm just going to be looking into it and showing you what was different, or what is different from the one that I've shared with you earlier. So we have the name of the firm, then the address of the addressee as per usual, and then attention, Mr. A.A. Thomas. I'm substituting names as usual. No revelations that are unnecessary. So here I attentioned someone, the person that really, was involved in the matter and that had the lawful authority and capacity to actually attend to what we were asking for. So I said, attention, Mr. A.A. Thomas, Chairman and CEO, Boston Group of Companies. So, dear sir, the title here is a little bit different from the other one. Here we just titled it, what we wanted. Very important, so that anyone looking at the letter will already understand what they will find in the letter. So we titled it wrongful termination, payment of reasonable commission on project executed, and recovery of other accrued benefits due to Mr. Shola Bamikoli. So that is our title. So we said we are solicitors to Mr. Shola Bamikoli, hereinafter referred to as our client in quote, and we have his express instruction to write you this letter. Our client informed us that sometimes in May 2015 he was offered employment in your establishment as business manager for your group of companies. An offer he duly accepted, resuming work in earnest on the 5th of May 2015. So that's the second paragraph introducing our client's brief as he informed us. Very important. Do not assume first person here when you're writing your letter. You have to report it as your client informed you. Then we now subheaded the issues involved for clarity. The first issue is payment of commission due. Then we told them what our client told us had happened, and what it was due and how it wasn't paid, and then we told them what was supposed to have transpired, how things should have gone, which it did not go that way. We told them that. And then the next heading, unlawful termination, constructive dismissal, we also explained that in detail. We now pointed out eventually the fact that our client has tried to resolve the issue amicably, unsuccessfully through several avenues over a period of months, you have to point that out. And this is why it came to writing this letter. Then the next subheadings are demands. Never end a letter. Never get carried away that you don't put your demands. Very important. So don't be like the tortoise that went to his in-laws house, and instead of asking for the daughter in marriage, he was asking for something else, concerning himself with something else. So we do our demands. In the light of the foregoing, we have the instruction of our client to make the following demands. 1. We hereby demand that our client be paid the sum of so and so and so. Then 2. We also demand that our client be paid the sum of so and so and so. So all those things, the demands, you itemize them. And here's how we close this one. We said, take notice that if our client's demand are not met within 14 days of your receipt of this letter, our client will be left with no option than to take legal action against you. This is without prejudice to the right of our client to further report this matter to the relevant government authorities. We thank you in anticipation of your full cooperation. That's how we ended that letter. You see that? Polite but very firm. We even gave them an ultimatum because, some people would, not do anything in good time. So we gave them an ultimatum of 14 days. So if you don't respond to us in 14 days, reasonably now, not just that you respond and give us holding response, So if you do not respond within 14 days, we are going to court. And not just that, we are going to report to relevant government authorities. And that's what we did, because this particular this particular company did not respond. So we reported them we petitioned them actually. So, and we got results. Eventually, we had to go to litigation even after the petition. So that's how it works. So you make sure that you put the best foot forward for your client. Don't be rude when writing your letter. Don't be hasty. Don't misinform. Don't misrepresent. But don't be weak as well. You need to be firm and polite in writing your letter. And then, of course, we sign yours faithfully, name, role, signature, company. Or you could do signature, name, role, and company. And you put your seal, your NBA seal, and probably your stamp if you have it. So that's how to write a letter of demand or a cease and desist letter on behalf of your client as a lawyer in Nigeria. I hope that you watched this video in detail. Probably go back in time if you've missed any, or if you need to understand better some of the things that I've mentioned in this video. I will see you in my very next video, and don't forget to subscribe to the channel. Toodles.